Our today's topic is possession. Under our Indian law, possession occupies a very central and dominant role. Let me share with you, it is one of the basic and most dominant instinct of human beings to possess things. First, let us understand what is meant by possession. Possession means voluntarily or intentional or deliberate physical control over the property. Thus, it indicates one will have an exclusive use and enjoyment of the property. Furthermore, if somebody makes an interference over such property, he has every right and authority to prevent that man's illegal interference, if necessary, by filing a case. We should also understand, under our law, possession has been given a great importance. It means if there is no other source to establish title, it is a possession which will be taken as a guiding factor to determine the title. If one reads section 110 of Indian Evidence Act, it says person in possession is presumed to be owner. It means in the absence of title, possession has a very crucial role to determine the title. I should also tell you, in the event of disturbance of possession, either by way of illegal interference or snatching away the possession, under law there are certain recognized remedies. If there is a mere illegal interference, injunction is the best remedy. If somebody snatches the property, the remedy is suit for recovery of possession. Apart from that, there are certain other remedies like mean profits, damages. Under criminal law, we have a remedy called criminal trespass. I should also tell you, possession is such an important thing. If we read either theft or criminal trespass, it is not the ownership that is the principal question. It is a person who has a possession. Therefore, it arises whether possession means occupying illegally or grabbing somebody's property. The answer is no. Possession means holding a property, physically controlling a property through a recognized or legal means. Now let us turn to those recognized legal means. Under law, there are many recognized legal means to call that oneself is in a legal possession of the property. We have already studied sale, exchange, gift or hiba, will, partition, succession, adverse possession. Let me share with you all these things. There is a transfer of ownership. Ownership means a bundle of interest, which also necessarily includes transfer of possession. Therefore, a person can acquire possession in this country either by way of a sale, either by way of exchange, gift, will, partition, succession, or adverse possession. The left hand side things like lease, mortgage, settled trespasser, assignment, section 53A. All these are not ownership. They are only guarantees right of possession. To put it otherwise, under lease there is a transfer of right of enjoyment. That is the exact meaning of lease. So, as enjoyment can be done only if there is a possession, a person can lay a claim that he is in possession of the property by way of a lease. So, lease is one of the recognized mode of acquiring possession. Mortgage, a person can obtain a loan by transferring his interest over immovable property is called mortgage. Under mortgage, there are varieties of interest can be transferred. But if a person transfers his right of possession of immovable property, that person, if there is illegal interference by the original owner, as there is a transfer of right of possession, he can certainly make a claim of either injunction or recovery of possession as long as this right of mortgage is in subsistence, the contract of mortgage is in subsistence. Similarly, section 53 of TP Act, this is also not a complete ownership. This is only a contract for sale wherein a person by paying some consideration or by entering into a contract for consideration acquires possession of an immobile property and ready and willing to perform the remaining part certainly can claim that he is in a lawful possession of the property, provided at the time of contract he obtained the possession of the property. Moreover, that written document shall be registered. To put it in one word, if a person by way of a written registered instrument acquires possession in anticipation of a future sale, definitely he can make a claim of possession, right of possession. Now coming to the issue of settled trespasser, a person having illegally acquired the property, continued for a length of time, maybe for 1 year or 2 years, and undertook some activities over the same, he can also definitely make a claim over the property stating that he has a right of possession. In fact, there is a proposition that a person in peaceful possession, even though he is a settled trespasser, can definitely prevent the illegal interference of the original owner. The only remedy of the original owner is file a suit for recovery of possession. And finally, assignment. The government, by way of various assigned laws, can assign its land, and that person assignee can certainly cultivate it, enjoy it, and also prevent the illegal interference of the government also. In such a case, the government, despite it being a owner, cannot take that man's possession. The only remedy available to the government is either file a suit, either obtain it by way of a Land Acquisition Act, or by following the procedure prescribed under assigned laws. Thus, a person in possession shall be protected by the law. Therefore, it is all the more important for a law student to understand what is possession, what are the various modes of possession, what are the remedies available in the event of disturbance or snatching away of the possession. That's the end of the class.